Yeah. So that's what I'm saying. So instead of trying to hide from the fact and hide it, sometimes they have to be discovered. I've told everybody in my group, do you know I've learned more about court from people's losses than I did from a win? Because in a win, all they do is just affirm, hey, we agree. It's not hard. Hey, we agree. But if you see when people lose in court, the opinions, and many times the judge, I'm talking about Rule 12b6 motions, summary judgment. In many cases, especially the sovereign claims, they will actually tell you why you lost on these claims. You lost because the court does not have subject matter jurisdiction over these claims. That right there is major, because the courts lacking subject matter jurisdiction over 99% of these social media claims. That means that what's being promoted online today has no legal merit. It means nothing in court. When you present a claim and the judge doesn't even have subject matter jurisdiction over that claim, that is a problem. That means your complaint is dead on arrival. Your complaint is dead on arrival. So I'm going to get into the complexities. I'm going to get into the complexities of court. And want to know why? Because a lot of people, no matter how much you go over the rules and procedure, no matter how much wins that you have, no matter how much, a lot of people truly believe that all you have to do is just understand the rules and procedure, and that's all you need. And I'm here to tell you that that is 100%. Let's go down. That's 100% the bare minimum of what you need. So let's go. Let me go here. Let's go here. Right. The court rules of procedure and validating the evidence, attacking the business records. That's the bare minimum of court. That's the bare minimum that you have to do. That's not anything that, there's nothing in court that's a 100% end all be all. Let's go. Okay. So this is the let me see. This is the complexities of how court can get. So I'm going to start with two. YouTube, we're on YouTube as well. YouTube double stream from YouTube. Yeah. So it says the order says plaintiff showed a chain of assignment. Actually had this sent up to the lawyer, to an attorney, actually before, one of my group members and friend, he has friends with a lot of attorneys. So I said, hey, I want to teach a class. So let me know what y'all think of this. Make sure it's cool. So they're like, yeah. This is sufficient. Sounds about right. Even the attorney said, oh man, appeal. Because they know that sometimes the judges do get it wrong. And you're going to see why I've spoke about the prejudice when people are in default versus when your account is current. I know online, and I know probably for most people in credit card cases, they think that doesn't matter. But I'm going to tell you, you've been around for at least a decade. I'm going to tell you, especially when the stakes are higher, a credit card case versus a auto case and a mortgage case, I'm telling you, the preparations are not even in the same field. Many people still think that you can argue a auto and a credit card case on the same way as you argue that mortgage in an auto case, the same way that you argue the credit card, and you just so happen to be successful with that $500 balance. No, it's a totally different world, totally different ball game. And if you are a impatient litigator, meaning you're expecting court to be over after you filed your filings or responded, and you believe that they don't have nothing left, when you're dealing with an auto, especially mortgages, be prepared for the court to drag out for a couple years. Now you got to have legal stamina. Says, I'm gonna start right here. The matters because Dresser versus Birch is not a generic summary judgment case. It is the Ohio Supreme Court's key burden shifting case. Dresser holds that the moving party must identify Civil Rule 56C evidence, affirmatively demonstrating the absence of a genuine issue of material fact before the burden shifts to the non-moving. So, Civil Rule 56C, evidence affirmably demonstrating the absence of a genuine issue of material fact before the burden shifts to the non-movement. That means the movement, they're saying, Your Honor, here's the debt. They didn't challenge the debt from a legal standpoint. Just merely saying, I don't owe that isn't good enough. Now they have to, the burden is on them to produce evidence showing that they don't owe that amount. Right? But the case does not say that the burden shifts merely because the movement filed a motion with an affidavit attached. So if the affidavit's competency and foundation were directly challenged under Civil Rule 56E, the trial court had to resolve that threshold problem before it can conclude that the plaintiff met its burden. See, this is what you go on appeal. This is an issue because under Civil Rule 56E, the evidence was challenged. Now the judge has to make an inquiry, pretty much resolve the challenge, resolve that little dispute. Remember I told you court, there's little in-between motions, in-between challenges inside of the whole case. There's little in-between parts in the court. We call them the nuances of court. There's no in-between victories. The teaching point is that a court cannot lawfully compress Civil Rule 56 into this formula. Plaintiff filed an affidavit, therefore defendant had to file something better. And that's pretty much what the court was actually pretty much trying to say. Well, they filed this, you got to file something better. But if they filed this and you challenge that, now the court has to stop and address the challenge. Not shift the burden like, well, I'm not going to address it because they filed it. Now, what do you have better? That is not the sequence that Dresser requires under the Dresser court. The proper sequence is first determine whether the plaintiff's materials are competent Civil Rule 56 evidence. Only then ask whether the defendant came forward with specific facts. 2, the order says plaintiff showed a chain of assignment. The second inconsistency is that Karen's filings repeatedly argued Velocity had not produced a complete, authenticated chain of assignment tied to the specific account, either at the complaint stage or through proper Civil Rule 56 proof. The answer, the defendant's motion for summary judgment and the opposition each raised some version of that point. The problem is not simply that assignment was disputed in the abstract. The problem is that the record, as Karen framed it, lacked competent proof that Velocity owned this account and had the right when the case was filed. Schwartz is the anchor here. The Ohio Supreme Court held that standing is required to invoke the jurisdiction of the common pleas court. That goes back to that subject matter jurisdiction. So if you don't state a claim upon which relief could be granted, the court lacks subject matter jurisdiction. See, most people think that a Rule 12b6 motion or summary judgment is filed because it's just your like your arguments are weak or you don't know what you're doing. No. Especially in Rule 12b, motions to dismiss. That's basically saying courts, they have not stated a viable claim in which you can give them relief. So this court even lacks jurisdiction to hear their claim against us. That's all it's saying. From a legal standpoint, many people think it says, oh, they just try not to hear the truth, or they're lying, or they're crooked. No, that's from a legal standpoint. That's what it's saying. Now, common pleas, that standing is determined as of the filing of the complaint, and that a party that lacks standing at filing cannot cure the defect later by obtaining the necessary interest. The court also clarified that dismissal for lack of standing is without prejudice, which is another reason to understand the nuances of court. So remember when I told y'all where what they're really supposed to be doing is dismissing the plaintiff's case with prejudice? And they stopped that practice decades ago, especially if they're bringing a suit against a defaulted borrower. And that's a practice that every court in America uses now. Because if they dismiss the case with prejudice, they can never sue you ever again. So the court stopped by dismissing these cases with prejudice. It will give the borrowers the mindset that all you got to do is stop paying and then challenge faulty records and you're good. Now, when they dismiss them, they're giving the plaintiffs enough time or giving them the opportunity to refile again. Especially in mortgages and autos. You're rarely ever going to see a motion to dismiss with prejudice or the judge dismissing the case with prejudice outside a stipulation of dismissal. You're never going to see that in mass. Mortgage, auto, they're not stopping. If the fight is on. The important limitation, however, is the one that we will specifically break down on appeal. Schwartzwood does not stand for the broad proposition that every assignment document must be attached to the complaint in all cases. The better understanding is that the trial court's order appears to use a present tense or eventual proof approach. Quote, plaintiff showed a chain of assignment instead of asking whether the Civil Rule 56 record proved that standing existed at filing. This is a materially stronger appellate argument and a more accurate way we will use Schwartzwood on appeal. By tying Schwartzwood into an argument based on the judge's order, we bypass how we argued it at trial as we now shift to the appellate court, which applies the law and the controlling standard. So we don't have to re-argue Schwartzwood again. We can now re-argue it based on the order. This is why, for the record purposes, kept going back to at the time of filing, because I understood the Schwartzwood standard. So this is called preserving the record. You will watch, if you watch court cases on YouTube, there'll be sometimes attorneys know that they're about to lose, but they just want to preserve the record. So they start making their additional arguments and stuff to preserve the record. They know they're about to lose. I know they're about to lose. Everyone in the courtroom knows they're about to lose. The judge gave every indication that they're not really trying to hear from them. I watch it every day. I actually got the court channel on mute right now. I watch it every day. And every day. And every day. Oh, shoot. Sorry. God damn it. Hold on. God damn it. And every day I see cases where I'm like, yo, judge, are you okay? And I've seen cases where the judge like, I'm sorry, Your Honor, respect, you have to disagree here. Yeah. Oh, it gets testy in our courtroom now. The order says defendant raised technical legal arguments rather than fact-specific arguments. The third inconsistency is conceptual. Standing, admissibility, and authentication are not operational or trivial technicalities. They are threshold legal questions that determine whether the plaintiff's factual showing can legally count at all. Cairns' opposition expressly argued that the affiant lacked personal knowledge, that Linden Club's records had not been authenticated, and that standing had not been proven through competent evidence. Based on what they filed. See, what just wasn't a broad, oh, they do. No, this is what they have. This is what the controlling law says. They're basically just disregarded what controlling law says. Okay, here's what the civil rules say. They're not doing that either. And that standing and that been proven through competent evidence. These are not side issues. They go to the legal sufficiency of the summary judgment record itself. Tokels is useful here, although must be used carefully because it is not a debt buyer case. It is relevance. Its relevance is procedural. A higher courts may consider only evidence of the type that will be admissible at trial when ruling on summary judgment. I said this 2 days ago. I've been saying this for months. When it comes down to a motion for summary judgment, the evidence that they're presenting in the summary judgment motion, they are telling the courts, since it will be admissible at trial, there's no need to go through the proceedings anymore. So as a matter of law, I'm entitled to relief because the defendant has not presented any evidence that created a genuine issue of material fact. So summary judgment is all going to boil down to the evidence that they're relying on for the summary judgment. Is it admissible at trial? Yes or no? That determination is going to come down to your local jurisdiction's civil rules and procedure, rules of evidence, business records, objection to the hearsay rule. Yeah. That principle, combined with Civil Rule 56E, means admissibility is not a technical afterthought. It is part of the threshold inquiry. In the same way, Osherow makes standing dispositive, not decorative. So when a court dismisses preserved admissibility and standing objections as merely technical legal arguments, it risks conflating legal sufficiency with formalism. The teaching point is that debt buyer cases ought to become vulnerable precisely because trial courts normalize affidavit-driven practice and begin to treat admissibility objections as fussy or hyper-technical. But an appellate court reviewing summary judgment de novo is supposed to return to the sequence. Is the evidence competent? And if not, why did the burden shift? That is appellate court. Under the rules, under our controlling precedents, did the trial court err? Assignment of errors, whatever you want to put there. Did they err when they concluded that the evidence submitted was admissible, would have been admissible at trial under the rules and under our controlling precedents? If not, they got to go back and remand and start from there. The order applies defendant failed to present specific facts under Civil Rule 56E. The fourth inconsistency is that this analyst only works if plaintiff first presented competent evidence. One thing I don't ever move to the beat of the plaintiff's drum in court. I am not going to go down the path they want me to go down if they did not satisfy their initial burden. The burden does not shift on me until you satisfy the initial requirements, your initial burden. Plaintiffs, debt buyers, lenders, they always want to silently shift the burden on you. Hey, you owe $20,000. There you go. Hey, look at this affidavit. We got it, Your Honor. No. Let's stop and look at the affidavit for a second. Hold on. We got to make the civil rule inquiry. Hold on. Oh, I have personal knowledge of this. Hold on. I got some questions now. See, this is what they do. Just because the civil rules say in the ordinary course of business, all they got to do, all they think they got to listen. I just went through this several weeks ago with a client in mortgage with Loan Depot, literally in court. What did the witness say? Questions. Are these your business records? Yes. Did you rely on them in the ordinary course of business? Yes. Are the numbers accurate? Yes. All right, that's it. Oh, we was like, oh, how? How did you rely on them in the ordinary course of business? Hey, how did you configure those numbers? Well, it's 24. No. I know you're reading them from a screen. How did you get to the calculation? Did some of their monthly mortgage payments goes towards those premiums? And did you receive a insurance payout for those premiums? Did you reconcile the account? What about your allowance for credit loss? Since they're in default, there's no more expected future cash flow coming in. You write them off the books. You understand the ASC, don't you? So in that situation, why didn't you debit the ACL account and credit the receivables account to net the carrying amount before you present the final balance? I mean, I know that's what you're supposed to do. Stop them dead in their tracks. Oh, you think I'm a numbers guy? I'm an accounting guy. This fall, we'll be signing up for Robert Smith at the University of Maryland. Going for my master's in accounting. Why? Just to be nosy. The little technical insight, just to be nosy, see what's going on. I know they're not going to talk about what I talk about at SAU. I know they're not going to get in that in depth, but I'm just going to be nosy. Just, be nosy. So you got the affidavit. Hold on. Hey, you didn't even have an affidavit. In this case, all you just had was the closing documents. No bill of sale, no nothing. But they think that just because they have it, it satisfied the records. But the challenging of the business records causes them to shift uncomfortably in their chair because they're not expecting you to challenge the records. I was just on 100K's live stream earlier. They literally had the same document, the same affidavit, the same word, the same sentence, the same font. And what was the thing that I picked up on? I don't know if many people saw it. They all had that phrase. We use this in the ordinary course of business. How? I mean, in the securitization, we come on, let's not act like that. Those authoritative copies aren't being transferred over to the custodian, and then they're putting them in their system for the trust and the collateral agent. Those are not just your same records just right then and there. They comprise of multiple records. Loan Depot, I know you made a mistake. You had one version of the exhibits redacted. Then when you filed the updated figures, you forgot to redact that little part right there. So we already seen the GMA investor relations. So we already know that part of your screen and the records you rely on came from third parties, because Loan Depot has their specific heading on them. And then the ones that we challenge, of course, say, where's the heading at? How do you know this actually came from y'all? So, and then you hear that awkward, weird silence. See, this ain't just legal motions back and forth. This is open court. That it's clearly what I'm talking about is accurate because it played out in court in real time. And guess what the judge did? The judge knew. It took almost an hour in before the judge to finally say, okay, Your Honor. I mean, okay, counsel. I'm intending to agree with the defendants. These numbers just aren't adding up. I'm starting to agree with the defendants. What do you mean you're starting to agree? We've been saying the same thing for the past hour. So it goes to show that the judge initially was just not hearing it. Want to know why? Because they were in default. That means something. Because plaintiff relied on Karen's opposition, argued the opposite. The fourth inconsistency is that this analysis works only if plaintiff first presented competent evidence. Karen's opposition argued the opposite because plaintiff relied on a post-filing affidavit and unauthenticated records. The initial burden never shifted. See, they think just because they filed those papers that the burden automatically shifts. Just because it says an affidavit on it that it shifts. No. This is a critical distinction. A non-movement is not required to out-affidavit legally insufficient summary judgment material in order to survive. If the movement's proof never clears the admissibility threshold, the court should deny the motion without ever reaching the specific fact stage. You see how the judge just skipped it? Again, this is where Drescher does real work. Drescher does not permit a trial court to say the movement filed materials, therefore the non-movement had to respond with better materials. That's exactly what the court was saying. And I was telling the judge, Your Honor, I'm not saying you're wrong, but I'm saying we challenged the actual, and you never made an inquiry on whether it was sufficient. You just kept ignoring it. Drescher says it. Civil Rule 56 says. So you're supposed to make an inquiry under Civil Rule 56. The movement must first identify proper Civil Rule 56C evidence showing no genuine issue. Only then does the non-movement need to respond with specific facts. Set. One central point from this case, it is, do not let a court collapse a Civil Rule 56 into plaintiff filed an affidavit, defendant needed a better affidavit. The sequence is really the law. Inconsistency relates to filing. Let's get to, let's move down. Cases supported by the defense position in teaching the right appellate principles. Federal Home Loan Mortgage versus Osherow. This is the anchor case. The Ohio Supreme Court held that standing is required to invoke the jurisdiction of the Common Pleas Court. That standing is determined as of the filing of the complaint, and that a litigant cannot cure lack of standing after commencement by later acquiring the relevant interest. Always watch the record. They're always going to try to slide something new in there that wasn't there when the complaint was filed. Starts right there. The court further held that the dismissal for lack of standing is without prejudice, though. This supports the proposition that the trial court had to examine whether Velocity's right to enforce existed when the suit was filed, not whether the plaintiff later assembled enough paperwork to get across summary judgment. This is exactly how Karen's filings framed the issue. Not merely that proof was missing from the complaint, but that no admissible records show ownership at commencement. Drescher versus Burt. Drescher is the summary judgment burden case, and Karen's opposition properly invoked it. The Ohio Supreme Court held that the moving party must identify Civil Rule 56C evidence demonstrating the absence of a genuine issue of material fact. The burden does not shift merely because the motion was filed or because the movement made conclusory assertions. Remember the same legal conclusions that I tell people not to make? Well, that's exactly what the plaintiff did. This helps Karen's argument because her opposition expressly took the position that plaintiff had not met the initial burden due to reliance on a post-filing affidavit, unsupported assertions of ownership, and unauthenticated records. In other words, our defense did not merely contest the merits, it attacked the threshold burden under Drescher itself. Checkmate. Tokels and Son Inc. vert Midwestern Identical. And the mere fact that really the judge was citing the same cases I cited. The judge referenced the same civil rule procedures that I referenced. Cited a lot of the same cases I cited. One thing is that these lawyers are going to have a problem is that the legal case law research is impeccable. They're going to have a problem with that. The case law research is impeccable. I wasn't offered a job at a law firm as a paralegal for no reason. If it's there, I'm going to find it. If it exists, I'm going to find it. Tokels is not a debt buyer case, by the way, but it's useful for the proposition that summary judgment evidence must be of the type admissible at trial. That was the narrow and proper way to argue it. The value of Tokels is that it reminds set students and litigants that summary judgment is not a relaxed evidentiary free-for-all. The evidence cannot properly be admitted at trial. If the evidence cannot properly be admitted at trial, the court should not rely on it to grant judgment as a matter of law. And if they still do it, you have an appealable issue. Every appellate court in America, every court in America, every judge in America, every lawyer in America knows that summary judgment boils down to was what the evidence we're relying on, the records we're relying on. Will it be admissible at trial? Every legal, non-legal, anybody that knows court understands that. The reason why people lose so much on summary judgment because they start bringing up issues that didn't even have anything to do with the plaintiff's claims. They'll file a motion for summary judgment and they'll respond with the wet ink signature proof. They'll respond with, I gave you the money. See, those are the losses I'm talking about. And they don't have not one case law cited, no civil rules in their response, just whole social media online arguments. That's what I'm talking about. This is the legal requirement that nobody teaches pro se litigants. The attorneys always word their MSJs to not tip their hands as to the elements required. They will never say, if we were to go to trial, the evidence would be admissible. This helps Karen's argument because the opposition specifically challenged the affidavit, the post-filing, and records on admissibility grounds. We argue that the affiant lacked personal knowledge and that the records were not authenticated under the business records rule. Tokels is useful not because it decides a debt buyer case, but because it supports the broader proposition that evidentiary sufficiency matters at the summary judgment stage. And if they can't prove the amounts due with reasonably with the facts and evidence to back it up, the court cannot in good faith grant them the judgment. This is why the court in Lone Depot, they keep continuing the trial. We'll be in court for 2 hours each time, and the judge says, this is too technical, I'm gonna send it back. They can't put that final order in because one of the elements of a claim is the amounts due, the accurate amounts due. The mere fact that they have a securitization and the mere fact of how the authoritative guidance on their accounting for their financial statements of position it puts a brick wall in front of them. That's why I use accounting so masterfully against all of them, because I know the mere fact that you have these numbers here, I know that they're inaccurate. But I don't use it to be like, look, the accounting says this. No, I tie it back under the court rules and procedures. Accurate amounts due. See, I don't throw accounting out there. This is an inaccurate amount. Here's why. And it stops them right in their tracks. I mean, you should get a hint. Just look at the average deed of trust and look at the priority of payments. Just start there. Man, you'll be paying by the time you get to your principal balance, you'll be on year 10. Oh, shit. Go back. Velocity versus Kunstler. Kunstler must be taught carefully. This is going to be carefully. It is not a clean defense win case. In Kunstler, the second district affirmed summary judgment for Velocity because plaintiff attached documents showing the assignment chain and because the defendant did not file a response to the summary judgment motion. The opinion indicates the record included assignment documents tracing the account and that the absence of an opposition mattered. Kunstler still helps here because it does comparatively rather than directly. In Kunstler, Velocity had assignment evidence in the record and the defendant did not oppose summary judgment. In her case, and knowing the technicalities of the Kunstler court, our defense did not oppose and specifically attack admissibility, standing, and authentication. So Kunstler is not proof that our defense position automatically wins. It is proof that appellate review depends heavily on what the summary judgment record actually contains and whether the defendant preserved objections. That distinction supports our argument that the trial court here had to engage the objections rather than simply treating Velocity's filings as presumptively sufficient. And this is why we moved for our own summary judgment in this case, just in case she lost. We preserved that argument, which Kunstler favors. Tenevsky is another case that comes with precision. The 10th District reversed summary judgment because the evidence demonstrated a genuine issue of material fact for trial. At the same time, later Ohio materials cite Tenevsky for the narrow proposition that some objections to a complaint's attachments may be waived if not raised properly under Civil Rule 12e. That means Tenevsky is best connected to an argument in this way. It supports the broader proposition that the debt buyer summary judgment can fail when the evidentiary records is insufficiently developed or leaves genuine issues unresolved. It should not be overstated as a universal complaint attachment rule. Our MJS used Tenevsky as part of the argument that conclusory allegations of ownerships are insufficient at the summary judgment stage, and that it is the best way to grasp it. Midland versus Hottenroth. Hottenroth is a reoccurring citation in debt buyer's teaching, but Seth needs to understand important nuances. The Ohio Supreme Court later dismissed review in Hottenroth as improvidently accepted. So the Supreme Court's 2016 entry is not a merits decision endorsing all propositions attributed to appellate opinions. Still, the Hottenroth litigation is part of the broader Ohio discussion about debt buyer evidentiary practices. And even the 2016 Supreme Court materials reflect concern with how these cases are litigated, nuances of court. And this is why we don't rely on one or two controlling cases. We rely on a multitude. That means Hottenroth is best used as a contextual or persuasive teaching authority about reoccurring affidavit and records problems in debt buyer litigations, not as a clean, binding Ohio Supreme Court merits holding on the exact issues in our case. Our filings use hot and Roth for proof of default and ledger-related themes. U.S. Bank versus Richards. Our opposition cited U.S. Bank versus Richards for the proposition that records originating with another entity cannot simply be adopted wholesale without proper foundations showing familiarity with the prior entity's record-keeping practices. That is one of the biggest things that pro se litigants miss every day, right there. If you don't spot that out or at least get it on the record, you're going to waive it if you got to go on appeal. The proposition that records originating with another entity cannot simply be adopted wholesale without a proper foundation showing familiarity with the prior entity's record-keeping practices. So if you are in a securitization, or if there's been evidence of it, or you can prove it was, if you're dealing with a GSE, the collateral agent, the trustee, they always have their own separate record systems. When they're transferring the security interest and the right to receive payment to the trustee for the beneficiary of the participants, they have their own set of records. When it gets to court, they're going to get a printout of those people's records. Do you actually think a mortgage servicer company actually knows how the collateral agent maintains those records? The foundation starts with you already have to know it's been transferred there. So you have two different entities. You got one that is just managing the collateral, the principal interest payments. You got ones that service it. When the servicer integrates those third-party records, how are you familiar with their records? How do they keep the records? What's the database used to store the records? You see what I'm saying? The Ohio opinion that appears in the search results shows a trial court's ruling that U.S. Bank failed to support summary judgment with proper Civil Rule 56C evidence, which is consistent with the evidentiary caution we're trying to argue. This helps our argument because our proposition argue exactly that. The affiant did not show familiarity with lending club's internal record-keeping practices and therefore cannot simply authenticate those records by assertion. This is universal. This is universal. Even if Richards is not the lead case in our appeal, it fits well into the teaching and litigation on why debt buyer affidavits are often vulnerable when they attempt to bridge records created by a different entity. Strongest appellate arguments based on this record: improper burden shifting under Dresser. This remains one of the strongest appellate issues. The order effectively says plaintiff filed affidavits and exhibits and therefore defendant had to produce specific facts. But our opposition argued that plaintiff never crossed the initial admissibility threshold. This is a strong issue because it goes to procedure and sequencing, not mere fact weighing. Appellate courts review summary judgments de novo, which gives this argument real attention. The connection to our filings is straightforward. We directly argue that plaintiff failed to meet its initial burden, not merely that plaintiff's versions of events was wrong. This makes the issue structurally appellate in nature. Failure to resolve the Civil Rule 56E Evidence Rule 8036 challenge. We specifically argue that the affiant lacked personal knowledge of lending club's records and assignment history, and that the records were not authenticated. If the affidavit is defective, then the order statement that plaintiff met its burden becomes unsustainable because the court would have relied on material that should not have counted under Civil Rule 56. See how you just put them right back in the pickle? This is another strong issue because it attacks the evidentiary foundation of the ruling itself. Tokels and the evidentiary cases we cited support the conceptual point. Not every filed affidavit is competent summary judgment evidence, and y'all should know that. Set class should understand that this is one of the most common places trial courts compress the analysis. It's always right here. Standing at filing analysis was incomplete or misframed. The order appears to conclude that plaintiff showed a chain of assignments and therefore was entitled to judgment, but it does not appear to conduct a Schwartz-Ward-style standing at exception analysis. This is strong because Schwartz-Ward is binding and explicit, but set class. You have to frame it carefully. The winning argument is not that all standing proof had to be attached to the complaint, but that the court failed to analyze whether the Civil Rule 56 record proves standing existed at filing. Everybody gets standing into one this broad. You got to have 5,000 things when you file. In many jurisdictions, no, they actually don't. So whatever it's filed, that's where the inquiry starts. It's not like you send them a letter. Hey, you're missing the chain of assignments in your filing. Let me get that so I can see it. If it's missed, if it's left out, go with what's there. And that's why when I see a lot of people online, their responses be, they're missing this, they're missing that, they're missing this, they're missing that. You didn't have this, you didn't have that. And the response is, yeah, you're right. Let me go ahead and dismiss this without prejudice and go back and tighten it up. So instead of telling them, hey, you forgot this, you forgot this, you forgot this, you should be like, well, based on what you have, just go by what they had. I see it all the time. It's like the defense always wants to overprove. And that's not your job. Their job is to prove their case. Like the defense want to, like these teachers get the defense to over. Sometimes no. The burden is on them first. If they don't meet the initial burden, you raise it, you challenge it, but you don't have to go down their path until they meet the initial burden under the law. The framing also aligns cleanly with our filings, which repeatedly argue the lack of admissible proof of ownership at commencement rather than merely procedural noncompliance with complaint attachment practice. The court minimized threshold legal issues as technical. This is not always a standalone assignment of error, but is a strong supporting point. It helps rhetorically because it suggests that the court may have brushed past admissibility and standing objections instead of actually not analyzing them. In a teaching setting, we explain the difference between legal sufficiency and legal technicality. Standing and evidence competency are threshold issues. They are not optional hurdles for the defenses to invent. Side arguments, not the strongest. This is more aspirational and based on the overwhelming evidence and defenses, but it's not the safest appellate prediction. Our MGS argued that Fainer failed to produce admissible evidence on standing, enforceability, default, and damages. This is a serious argument, but appellate courts are often more comfortable reversing the grant to the plaintiff and remanding the further proceedings than entering judgment outright for the defendant. So the reality is that reversal of the summary judgment looks more realistic than an appellate order granting defendants motion for summary judgment immediately. Oh yeah. That does not mean we waive the remedy request. It means SET will learn to distinguish between the strength of the error argument and the likelihood of the most aggressive remedy. Every argument has to be put in context. Stop thinking you're going to win on 5,000 arguments just because you argue them. Sometimes you could just be raising an argument just to preserve it on appeal. Competency set will learn how to stream. Those arguments, TILA, FDCPA, and usury things, those arguments have value in a broader consumer law class. And they may help SET students understand how debt buy litigation intersects with federal and state consumer protection laws. But for this appeal, they're not the lead issues. The most aggressive and stronger appellate issues are Civil Rule 56 issues, standing, affidavit competency, authentication, and burden shifting. The SET will learn how to be strategic. Not every preserved argument should be your lead appellate argument. Appeals are usually won by narrowing the best structural errors, and that's a 100p moment. Assessment of appellate chances. This is from the whole research and the litigation analysis. I will still avoid a numerical percentage based on the record and the order. However, the appeal presents serious, non-frivolous issues, especially on whether the court misapplied the Drescher sequence, whether the affidavit and records were competent Civil 56 evidence, and whether the court meaningfully analyzed standing at filing under Schwarzwald. Those are legitimate appellate points, not rhetorical complaints. The defense record is materially stronger than many pro se records because the key objections were preserved in three places: the answer, the defendant's MJS, and the opposition. That is a real advantage. The harder part is the remedy. Reversal of velocity summary judgment and remand appears more realistic than the appellate order granting defendants MJS outright, although the latter can still be argued as a preferred relief, aka, or in the alternative, reversing plaintiffs the order. Dead by cases often turn on procedure, not just account paperwork. Plaintiffs frequently assume that an affidavit and a balance statement are enough. But Ohio, in many worldwide cases, summary judgment law requires competent evidence, not just filed paper. This is why these cases could look routine at the trial level, but become much more vulnerable on appeal once the Civil Rule 56 sequence is enforced. Summary judgment is not who filed more paper. The paper has to be competent Civil Rule 56 evidence. Standing is not a vibes issue. It must exist when the complaint is filed, and the defendant does not have to out-affidavit a defective affidavit. If the plaintiff never meets the initial burden, the burden never shifts under the law. This is the real reason appellate courts matter in consumer defense cases. They force trial courts back into the correct legal sequence. The order can be taught as an example of a court saying, plaintiff filed an affidavit and exhibit, so defendant needed more facts. But the defense record supports a different and a more precise framing. Before the burden ever shifted, plaintiff had to prove ownership, standing, admissibility, and default through competent Civil Rule 56 material. That difference is the entire appellate battlefield. This is also the best teaching lesson for the class. Trial courts sometimes normalize affidavit-driven debt collection practice and move too quickly from papers were filed to burden shifted. Appellate practice forces the court back to the first principles: standing at filing, competent evidence, proper foundation, and the correct Civil Rule 56 sequence. If students understand that, they understand why many defendants in debt buy cases only begin to win once the case is viewed through an appellate lens. On the record provided, defense did more than simply deny liability or force the plaintiff to prove his case in general terms. The defense preserved and repeated a coherent set of arguments across three stages of the case: the answer, affirmative defenses, the defendant's motion for summary judgment, and the opposition to plaintiff's motion. Those arguments centered on lack of standing at filing, lack of competent proof of assignment, lack of admissible default, proof of default and damages, and defects in the affidavit and business records foundation. The answer raised standing at filing in the absence of a bill of sale, assignment, affidavit of ownership, or unauthenticated chain of title, and they challenged the lack of payment history or default proof. The defendant's MJS then recast those points into a Civil Rule 56 framework, arguing that plaintiff had not produced admissible evidence establishing ownership at commencement, enforcement rights, or damages. The opposition sharpened the argument further by expressly invoking Civil Rule 56E, challenging personal knowledge, authentication, and business record foundation, and arguing that plaintiff had not met its initial burden. From a neutral standpoint, that means the defense record was materially stronger than a routine pro se response. The issues were not left vague. They were preserved repeatedly and progressively more precision form. That said, there were also some weaknesses. Some arguments were more broader than necessary, and a few authorities were used more aggressively than their exact holdings permit. The best example is standing. The strongest version of the defense argument is that plaintiff failed to prove through competent Civil Rule 56 evidence that it had enforceable rights at standing. A weaker version is the broader suggestion that a weaker version of that is that the broader suggestion that all standing proof had to be attached to the complaint itself. Likewise, some of the consumer law themes, such as TILA, the points, may have teaching value, but they were not as strong as the core Ohio summary judgment issues. Oh yeah. Yeah. See, when you put a lot of, always say strongest, what are the best chances of succeeding on these? You lead with those. Then you have your secondary issues. Those are the ones that are like, well, I'm just gonna put it out there, just preserve, just put it out there. But those four up there is what we're relying on. Like in my case with CAC, I know all the claims I had. I know what a 10, 15. I didn't know 10, 15 was gonna win on those, but I knew the top four had that nothing they could say. So now that they had the ones that were actually entitled me to relief down pat, I can add the secondary claims in there. No issue. So a neutral assessment that the defense did well on issues preservation and on identifying the main appellate pressure points. That's the most important part there. But some arguments would have benefit from title narrowing around burden shifting, affidavit competency, business records foundation, and standing out exception. So they basically say if you just would have stood there, you didn't really have to bring in, TILA and all that. But the main appellate arguments, that's the most important. The judge's order, based on the record as presented, appears vulnerable not because it reached a plaintiff favorable result, but because it does not appear to have squarely confronted the threshold objections that were actually raised. If the court believed the affidavit and attached documents were competent Civil Rule 56 evidence, the order should have said why. If the court believed the assignment evidence was sufficient to prove standing at filing, the order should have explained how the record established that point. If the court believed the affiant was qualified to authenticate records originating with Lending Club, the order should have addressed the defense's evidence rule 8036 and Civil Rule 56E objections directly. Instead, as you described it and as your filings framed the issue, the order seems to move too quickly from the existence of an affidavit and exhibits to the conclusion that plaintiff met its burden and defendant failed to present enough contrary facts. This is why the strongest critique of the order is not that it was necessarily results driven, but that it may have been analytically compressed. And that is when they consolidate both motions. Basically, we're going to handle one. No. I was expecting to see 25 pages. Defense objections under Civil Rule 56C. The defendant objected, Here's why just let me consolidate it all at once so I can just nitpick, put this here, 4, 5 pages. That's it. I'm like, okay. A fair assessment without bias is this. Carrier's defense filings were substantially serious and preserved real appellate issues. They were not perfect and some points were broader than they needed to be, but they were legally engaged, record-based, and far more developed than a generic denial. The trial court could still have ruled for plaintiff or summary judgment if it had fully explained why the affidavit was competent, why the business records were properly authenticated, why the assignment evidence proved ownership by filing, and why no genuine issues remain. But on the present record, the order appears unexplained on those threshold issues. This is what gives the appeal real force. What the order more properly should have looked like on this record, a more appropriate order based on the filings and the issues actually raised, would have begun by stating the governed Civil Rule 56 framework and then expressly resolving the threshold evidentiary objections before concluding whether the burden has shifted. It should have stated that under Civil Rule 56C and Dresser, the moving party bears the initial burden of identifying competent summary judgment evidence demonstrating the absence of a genuine issue material fact, and that under Civil Rule 56E, affidavits must be based on personal knowledge, set forth admissible facts, and show the affiant's competency. The order should have then directly addressed defendant's argument that plaintiff's affidavit lacks sufficient foundation and that the attached records were not properly authenticated. If the court concluded that the affidavit was sufficient, the order should have said something like this: the affiant adequately demonstrated familiarity with plaintiff's record-keeping practices, adequately explained the integration and reliance on prior creditors' records, and sufficiently authenticated the attached account materials for summary judgment purposes. Nope. If the court cannot make those findings on the record presented, then the proper course would have been to deny plaintiff's motion without shifting the burden to defendant. The order should not simply have treated the filing of an affidavit as self-proven when defendant has specifically challenged personal knowledge, hearsay, and foundation. The order should have separated the standing issue from the broader contract enforcement issue. On standing, it should have expressly stated whether Civil Rule 56 record proved that plaintiff held enforceable rights in the account and when the complaint was filed, consistent with Schwartzwald. That analysis should have focused on timing and account-specific proof, not merely the present existence of some assignment materials. If the court believed the record established standing at filing, it should have identified the evidentiary materials proving that point. If not, it should have denied summary judgment or addressed whether dismissal was warranted. What the order should not have done is speak only in general terms about a chain of assignment without tying that conclusion to the defense preserved challenge that standing had not been proven as of commencement. On default and damages, the order should likewise have stated whether plaintiff's proof of amount due was supported by competent evidence beyond a conclusory balance assertion. The defense specifically argued the absence of a payment ledger, transaction history, authenticated proof of default. If the court believed the submitted account materials and affidavit adequately established those points, the order should have explained why. If the court believed there were factual disputes or evidentiary gaps, it should have denied summary judgment. A proper order in a case like this needs to show its work, because the whole fight is about whether the plaintiff's proof is legally competent enough to count. Finally, if the court intended to reject defendant's own motion for summary judgment, the order should have said so expressly and explained why defendant had not established entitlement to judgment as a matter of law. Cross motions, as he framed it, do not eliminate the need to analyze each motion independently. This is why he did not want to analyze it independently. On this record, the most careful and analytical complete order likely would have denied both motions unless the court was prepared to make explicit findings on competency, authentication, and standing at filing, and proof of default and damages. This is the most neutral bottom line. Based on the filings you provided, the order should have been more explicit, more segmented, and more transparent in addressing the exact threshold objections the defense preserved. Whether that would ultimately have changed the final result is a separate question, but the order itself should have looked more like a structured Civil Rule 56 analysis and less like a generalized acceptance of plaintiff's evidentiary presentation. This section answers the core question cleanly. What should have happened under Ohio law given this record? The analysis is grounded in how Ohio courts from the Supreme Court of Ohio down through appellate districts apply Civil Rule 56, Drescher, and Schwartzwald in debt buyer cases. Governing standards. Ohio appellate courts review summary judgments de novo and apply a strict sequence. Initial movement's initial burden, Dresser. Plaintiff must point to competent Civil Rule 56C evidence establishing each element: ownership, standing, default, amount. Admissibility gate, Civil Rule 56E, Evidence Rule 8036. Affidavits must show personal knowledge, competency, and proper foundation, especially when relying on prior creditors' records. Standing at filing. 3, source warrants. The plaintiff must have and been able to prove enforceable rights at the time the complaint was filed. 4, only then does the burden shift. If and only if the plaintiff clears those steps, the defendant must produce specific facts. Application to this record, neutral, no bias. Did the plaintiff meet its initial burden? On this record, the plaintiff relied on a custodian-style affidavit, account materials, general assignment assertions. The defense directly challenged personal knowledge, authentication of prior creditor records, chain of assignment tied to the specific account, proof of default and amount. Those are threshold admissibility and competency challenges, not mere disputes of fact. Neutral conclusion. There is material question where the plaintiff's evidence qualifies as competent Civil Rule 56 evidence at all. If that threshold is unresolved, Ohio law does not permit burden shifting under dress reverse burden. Did plaintiff conclusively establish standing at filing? The record is framed by all the filings. Everything shows no clearly authenticated account-specific chain of assignment. No explicit demonstration in admissible form that plaintiff owned the account when this suit was filed. Under a Federal Home Loan Mortgage Corporation versus Schwartzward, standing must exist at filing, cannot be carried later. Neutral conclusion. At minimum, this creates a legal sufficiency issue, and at most, a genuine issue of material fact on standing. Did plaintiff establish damages? The defense argued no payment history, no transaction ledger, no independently verifiable calculation of the balance. Plaintiff relied primarily on a balance assertion in an affidavit. Ohio appellate courts routinely scrutinize this in debt buyer cases. Without a properly authenticated account history, courts often find that damages are not conclusively established. Neutral conclusion. There is at least a triable issue as to the amount owed and how it was calculated. Did defendant meet the burden for its own MJS? The defendant's MJS argued plaintiff failed to prove standing. Plaintiff failed to produce admissible evidence. Plaintiff failed to prove damages. Those are defensive deficiencies, not necessarily affirmative proof entitling defendant to a judgment as a matter of law. Ohio courts are consistent on this point. Showing that plaintiff's case is weak is not always the same as proving entitlement to judgment. Neutral conclusion. The defense raised strong defects, but not conclusively established that no set of admissible facts could allow plaintiff to prevail. In this case, it's impossible. You can't. That's basically the only way you say that. Hey, I never even got a loan from Linden Club from the beginning. You know what I'm saying? This is not even me. I keep trying to tell them this is not me, but they keep that. Oh, she definitely got a loan. So you can't get, see, that would work if you mean to tell me you never ever received a loan ever from them? Yes, it could work there. What the proper ruling should have been based on Ohio Rules Civil 56 Civil Rule 56, dress averse burden shifting framework, Federal Home Loan Mortgage Corporation versus Schwartzward standing requirement, appellate treatment of affidavit-based debt buyer cases. Plaintiff's motion for summary judgment should have been denied because the court did not resolve admissibility and competency challenges. Standing at filing was not clearly established through admissible evidence. Damages were not conclusively proven through competent records. Under Ohio law, that means plaintiff did not carry its initial burden. Defendant's motion for summary judgment should also have been denied. And I agree. And I told the class, I said, I wouldn't be surprised if he denies both motions and make them to go figure it out. So I said, I wouldn't be surprised. Actually, I told him that's what I think. I think he's going to deny both. Deny both. Yeah. I just couldn't see 100% win 17 grand in the hole. Because defendant exposed deficiency but not conclusively established entitled to judgment as a matter of law. Yeah. You can't 100%. It's got summary. Remember, you got to look at the procedural parts of court. I'm not bringing a claim against them. They're bringing a claim. The proper, to be honest with you, another motion to dismiss. But your summary judgment, what are you trying to get the courts to give you? Ohio courts generally require affirmative entitlement, not just critique of the opposing party's case. You see what I'm saying? There's nothing that she was really entitled to. But I already understood that. I go in there, I already understood it. No, what are you entitled to? You're entitled to a judgment. There's no judgment for it. So I get that. Just preserving the records on the elements of the challenges to their case. Final disposition, most consistent with Ohio law. Both motions should have been denied. While this outcome aligns with Ohio appellate practice, this outcome is consistent with how Ohio appellate courts handle defective or contested affidavits, unresolved authentication issues, disputed standing at filing, incompetent damages records. Appellate courts frequently hold, and y'all, this is comprised for, I think it was 50 Ohio appellate court debt buyer cases. So it shows the consistency on how they rule on these things. So yes, I totally agree. Both motions should have been denied. When evidentiary sufficiency is disputed at the threshold level, summary judgment is inappropriate. That quote is taken from an appellate court ruling. It's literally taken from the case. That does not mean plaintiff loses the case. It means the case proceeds, evidence is tested, issues are resolved through trial or properly supported motions. Basically, we're going to deny both trials October 13th. Y'all get ready. Yeah. If you had, under Ohio law, this is not a case where plaintiff proved too much or defendant proved too much. It was a case where plaintiff did not prove enough and the defendant did not prove enough either. I agree. Yeah. Should deny both motions. You don't really have enough to prove that you owe the debt, own the debt, or could enforce the debt, or establish records of the debt. But you don't have enough to prove that you don't have to pay. That's very way to say. You don't have enough to prove that you just don't have to pay this. And this is the realities of court. They know you got the loan. They know you made payments on the account. You trying to say you just don't owe nothing at all? And that's the mentality pro se litigants think when they go to court. I don't have to pay. Remember, if you're the defendant, it's not like outside of them violating the law while attempting to collect the debt, you got to separate that from the elements of the case. It still doesn't mean that you didn't owe the debt. You signed the contract. You made payments on the account. Let's stop acting like that never took place. It's never a problem with the credit card when you're swiping. It's always a problem when the credit card, when it's time to pay, when there's a balance. So ask yourself a question. When you reach out for services in these spaces, are you actually reaching out because you need help and there's legitimate issues, or are you reaching out because you don't want to pay? This is why trial courts sometimes grant summary judgment based on routine practice, but appellate courts reverse based on legal sequence. And this is the key takeaway. Many defendants don't actually win on appeal because they discovered new arguments. They win because appellate courts enforced the rules that should have been applied the first time. What makes this case different from the CAC case? This is where the class needs to shift from procedural defenses to strategic posturing, because I did not do a procedural defense in a more higher stakes case. It was strategic posturing, meaning from the very first letter or document sent to them explaining the issues to the time the complaints filed to the day we signed on the dotted line for the settlement, everything was a tactical, strategic posture. You're going to explain the difference, why there's a difference in the position, why it's always a power move. The real difference is who controlled the legal posture at inception and what the account status was at filing. One thing that I hate, and if I could change it in these spaces, if I can Thanos snap my finger, is everybody always has to analyze what they filed. You got to attack their affidavits. You got to prove they don't owe. Nah. You analyze what I put on the record now. You analyze what I filed. You respond to what I say. Notice, think about, regardless, when you're the defense and default, you got to analyze their affidavits. Well, when is there ever going to be a time in this space where the legal counsel got to analyze your filings as a complaint? When is there ever a time when they got to analyze you? They got to respond to you. They got to move to the beat of your drum. When are you going to control the procedural posture of the case? Why is it always got to be, oh, I'm being sued, I need help? Procedural posture, plaintiff versus defendant. Karen's case is a reactive case. She is defended against a lawsuit filed by a debt buyer. That means the plaintiff controls the narrative at filing. The case starts with their version of facts presumed sufficient. The defendant must disrupt that narrative under Civil Rule 56. By contrast, your CAC case was a proactive case. You were the plaintiff. That changes everything. You denied the claims. You defined the claims, timing, and framing. You forced the defendant to respond to your legal theory. You were not trying to defeat a presumption. You were creating the record from day one. So I say from the very first document to the day we signed on a dotted line, everything was tactical, strategic, and they all moved to the beat of my drum. They had to move. They moved when I dictated the move. Remember, they notified me January 15th that they represent CAC. They didn't even make an appearance till we talked. And a week went by from the time they reached me to I responded, because the email was in the spam. And thank God I got a practice of reading the spam before I delete it. Wanna know why? Think about that. They waiting to hear from you before they move. You see who's controlling the scene the whole time? That's a power position. From a pro se litigant, they're moving to the beat of your drum. That is the position you want to be in. Not always, I got to react. They got to respond. What they put, okay, I got to say you don't got it. You can't do it. You talking about being free, being the king of your own jungle, or the queen of your own jungle? You talking about making multi-billion-dollar corporations move to the beat of your drum? I'm telling you, 99% of this spaces is response as defenses. And the other 1%, 9.9% of those plaintiffs, they're still in default or already in foreclosure. 0.1% of these spaces is plaintiff and current at the time the complaint was filed. Many gurus don't even have nothing for you in that position. There's no affidavits to look over. There's no business records to attack. You got to create your own claims from scratch. Do you know how difficult that is than using consumer defense laws? You can't even use it, all of them like that, because you're the plaintiff and you're current. There's no violation right there. You know how difficult that is? Do you know how astute you got to be to craft a complaint without the anchors that you would use if you're a defendant and they're trying to sue you? FCRA goes already out the window. What you using FCRA for? They're reporting you paid on time. FDCPA can't use that either. You literally got to, the arguments that you raise when you're current the plaintiff, rarely you're ever going to see them in pro se litigant defenses. Teaching point for all of you. Defendants fight uphill under Civil Rule 56. Plaintiff sets the battlefield. That alone makes your case structurally stronger from the outset. 2, the timing. Current versus defaulted status. I don't care what they tell you. I don't care about the credit card wins. Bring your ass over there to the auto and mortgage world I'm in, and let's see if that don't play or what. They ain't credit cards. This is the most important difference. Karen's case arises from alleged defaulted account. That means the plaintiff can rely on default, balance due, charged off narrative. Even if weakly supported, courts are conditioned to see these cases as the borrower didn't pay, the creditor can collect. In many cases than none, and not just because they didn't show up to court, in many cases than none, in jurisdictions, the courts are going to be prejudiced against you if you're in default. They just don't want to talk about it. Then they're not going to talk about it. Affidavits, incorrect, it don't matter. Somebody must have paid. Somebody must owe. That's why they come with the no free house doctrine when you're in default. Your CA case, you were current. You filed while current. This is a completely different legal environment. No default, no missed payments, no acceleration trigger, no damages in the traditional sense. Legal significance of filing while current. Filing while current disputes the entire creditor litigation model. Disrupts the entire creditor's litigation model. Number 1, no default equals no cause of action. They can't even bring me into court. In that cases, the creditor's claims depend on breach, default, damages. If you are current, there is no breach. There's no delinquency narrative. The creditor cannot rely on failure to pay. That forces the case into contract interpretation, accounting, and legal structure, not collection. Told you the arguments are totally different when you're current. And the arguments raised when you're current are the arguments they never want to talk about in court. That's why they like to hide behind the default, the breach, the damages. They don't want to talk about these. It forces a substantive case instead of a collection case. Karen's case, procedural defense, focus, prove you own it, prove the balance. Your case, substantial offensive litigation, focus, accounting treatment, securitization structure, enforceability, valuation. When you file while current, you remove the emotional and procedural shortcut of non-payment. It eliminates the court's default bias. Courts are used to high-volume debt cases, routine affidavits, minimal scrutiny. That creates a systemic bias. If someone didn't pay, they probably owe. When you are current, that bias disappears. The court must deal with legal structure, contractual rights, financial treatment. It locks the record at a favorable moment. Under Ohio law and general civil procedure, rights are evaluated at the time of filing. In Karen's case, the record starts after alleged default. The plaintiff controls the narrative. In this case, the record starts before any alleged breach. You control the framing. Teaching point for all. Follow while current freezes the case at a moment where the creditor has not yet triggered its strongest argument. That is 100% facts. Before they can even craft the argument, they got boom, blindsided with a lawsuit. Oh, well, what about now? He's current. Well, what about? He already addressed that. Well, what about? Well, you already admitted that you do that. Well, what if it? You've already filed these. It's public record. This is what you do. Well, what about? Well, that's going to expose you on the back end if you want to argue it. Well, what about? Well, really nothing you can say here. I mean, we could fight, but what are you going to say? None of what he's saying is true. Because now, you know, your investors, they may get a whiff of this. Now, it looks like you're lying. Burden dynamics. Who has to prove what? Karen's case, plaintiff. Minimum showing, affidavit, ballots. Bam. Defendant must attack everything. Even when the defense is correct, the burden structure is reactive and technical. CAC case, you impose burden on CAC to explain accounting treatment, ownership, structure, valuation. They never want to talk about it. This is much a heavier burden than prove the balance. Nature of the legal issues. Karen's case, procedural evidentiary, Civil Rule 56, affidavit competency, business record, standing. These are gatekeeping arguments. The other case, the CAC case, substantive and structural, nature of the receivable, economic reality versus legal form, accounting treatment, enforceability. These are system level arguments. These are basically, this is how you operate arguments. Not, I don't owe that. That affidavit is, that the signature is off. You don't know where those records came from. This is how you operate. Now say you don't. Here's a lawsuit. Go respond and say this is not what y'all do. Go ahead. I'm gonna give you opportunity. I'm gonna file a lawsuit. There you go. I'm gonna serve you. There you go. Now it's your opportunity to respond. Come on. Tell me I'm lying. Tell me what I'm saying is not 100% correct. Go ahead. Come on. You and I both know. Come on. While many defendants only went on appeal, Karen's case illustrates a broader pattern. Trial courts often accept affidavit-based practice. That's very true. I know in these space, I know it's when we attack it, they lose it. I get that. And that may happen in a lot of times. But if you look across the world, the same thing happened here. It's happening all across the world every day. The courts often accept affidavit-based practice. They compress Civil Rule 56 analysis. Appellate courts enforce sequencing, scrutinize admissibility, and revisit standing. This is why defendants often win on appeal. Not because the law changed, because the law was finally applied correctly. And the debt buy case, that is a reactive posture, default-based narrative, procedural attacks, burden disadvantage. You must undo plaintiff's case. And the CAC was a proactive litigation while current. Offensive posture, no default narrative, substantive legal issues, burden advantage. You define the case. The bottom line, the difference is not just debt buy versus auto loan. The difference is Karen is trying to stop a case after default. You built the case before default. Set you lesser for all. If you had to distill this into one principle, timing plus posture is the arguments. Follow while current removes default leverage, forces legal analysis, shifts burden. Wait until sued, put you in defensive mode, relies on procedural errors, depends on appellate correction. Why some borrowers in default still win, especially FDCPA claims. And that's why that's different from my case. It's the final layer your class needs to understand, because this is where most people get confused. If default is so powerful for creditors, how do defendants still win? The answer is this: they don't win on the debt, they win on the conduct. The key distinction: liability versus conduct. In default cases, even if the borrower stopped paying, owes a balance, breached the contract, they can still win because FDCPA focuses on the collector's behavior, not just the existence of a debt. That's why I say I'm not shaming the FDCPA, but that's only focused on their, like, you, when you're centered and you're focused around the FDCPA, you are stuck in that arena. You can't use that in the auto. You can't use that in the mortgage. They can still win because the FDCPA focuses on the collector's behavior, not just the existence of a debt. Under the Fair Debt Collection Practices Act, a debt collector cannot misrepresent the amount, misrepresent ownership, use false affidavits, pursue collection without proper validation, engage in deceptive or unfair practices. Debt can be valid and the collection can still be illegal. Why defendants win in default cases? Standing versus ownership failures. Debt buyers must prove they own the account. Valid chain of assignment, right to enforce. Many fail here. Courts have reversed judgments where assignments were incomplete, affidavits were generic, ownership was not proven. Affidavit versus evidence problems. He said, well, the court can say if you're current in your card agreement, what's the issue? That's the whole thing. That's my whole point right there. Forget a credit card. Forget a credit card. Let's jump up to an auto and a mortgage. Let's jump up there. That's what make what I'm talking about so rare. Because many people cannot fathom any argument when everything is good. They don't even understand, well, what would that's the main question that people always ask me. What would the argument be if you're current? A whole set that's not taught online. I'll just tell you that. What I'm talking about is not taught online. And anyways, just from a psychological standpoint, we always talk about being free. We always talk about getting out of clutches. You can't be free all the time by always waiting to be sued. I got into the auto contract February 29th, 2024. Right? March 1st, I said, let me look at this again. Let me look at this whole contract again. Uh-oh, something ain't right here. Something's not right here. I said, oh, my monthly payment's coming up. Let me go ahead and make that payment. Hey, shout out to the gift, shout out to Truth Seeker. I said, you know what? Oh, something is not right here. Oh, monthly payment due? Go ahead. You got that? I don't want to give y'all no reason by non-payment to, stop this momentum. April, payment due? Don't worry. You got it. I said, I got your ass. Oh, I'm lining y'all up. Oh, payment due this month? Don't worry. You got it. You got it. Don't worry. You got it. You ready to go? Lawsuit's done. You already got the discovery. You got your in-between motions? You ready? All right, pull the cord. Hey, remember the day I told you where you had to see me in court? You remember that day? Yeah, well, that date's here. So, as a final act of good faith, you're not going to get the full amount this month. I'm going to make a partial payment. Yep. Okay. Later. Okay. You ready? Yep. Here's the car information on the phone. Yep. 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 Make half. Yep. I'm going to make half. Yep. You got it? All right. There you go. Talk to you later. Lawsuit filed. Oh, credit acceptance. By the way, here's how I'm coming. Here go the first 29 pages of the lawsuit. You can get the rest. Oh, just because I like to be transparent, here's everything I'm asking for in discovery. I know you have it. I know you don't want to give it to me, but I'm gonna give it to you right now anyway. So if it gets to that stage, there you go. You got it right there. Oh, by the way, the credit acceptance. Look, you see that? I got you right there too. And these are emails. Oh, damn. I forgot to tell you how this. You know I got you here too, right? There you go. You go ahead and take that. Have your legal team look over that. Oh, damn. This your internal operations. You know you can't deny this. Go ahead and take that. P.S. You know we can settle if you want. You know we ain't got to finish this. We can settle if you want. All right. Talk to you later. Yep. Because here's the thing. A lot of people, this is one of the problems I see. A lot of people are just so centered on credit cards, but they have nothing for you in mortgages. And my whole aim, so I take high stake cases. Want to know why? Because this is part of, I call it commencing a repossession on them. And I call it commencing a foreclosure on them. Yeah. I repossessed against them. Get that shit. Give me that. Give me that title too. Whoever you saying I owe you, you pay it. I'm not paying you anymore. You pay it. I don't care how you word it, forgiveness, eliminate, whatever, you pay it. I ain't giving you nothing. You pay it. And I want the property. Free and clear. I don't want no liens on it either. And mail it to me too. I got everything I asked for. Clean sweep. Not from an FDCPA claim, directly from them. It's called obtaining the property without having to pay for it. Isn't that the outcome many people look for in these spaces every day? Keeping it when not paying for it. When I'm being financially responsible for it. 100% full ownership. Now you can legally put it in a trust. That's the benefits of current and the plaintiff. Not no, got to go back years later, got to go from the door. I'm just trying to change the mindset of these spaces to stop looking at litigation as another extension of a debt elimination process or get out of this debt tactic. If you don't have interest in this stuff when you're current and life's good and you got no on the surface issues, if you're not being curious George, even when there's nothing wrong, you just signed a contract, haven't even made your payment yet, and you're still, this is called being in control of your own domain. This is called understanding what's going on in everything, even in when you're current. What's the problem? There's not many people don't even look at their agreements until they're being sued. I'm trying to change that mindset. And when the stakes are higher, you are not going to be able to commence foreclosure or repossession on them if you are in default. It's not going to happen. They're not even going to hear it. That's only reserved for current plaintiffs. My whole Set You class series speaks on that. The core elements and what you have to understand. Because what you have to understand, current and plaintiff, is totally different from what you got to understand when you're defending. Remember, you have no affidavits to attack. You have no asserted balances, default balances to attack. You have no FDCPA. You have to understand systems. You got to understand structures. You got to understand internal assessments, internal assumptions, internal operations. You got to understand financial statements of position. You got to understand balance sheets. You got to understand everything that they understand. This is why I came up with the 5 lenses of the contract. That contract is viewed 5 different ways. And that's what Set You teaches you. It teaches you to understand the systems that are in place that actually creates the numbers on your contract. This is why I can look at any contract. I don't give a damn what it is. I don't give a what it is. None of these numbers are real. None of the numbers are real. By way of how their system operates, none of the numbers are ever real. And it's universal across the board. I actually just held I held a in my Supreme Elite team group talking about just showing them. Same systems. Autos, mortgage, credit, it's the same system. But the system I'm talking about is not the system from a consumer defense position. That's not the system. Affidavit versus evidence. Typical debt buyer model. Mass production affidavits, just like we seen earlier in 100K's live. Mass production. Same words, just different signature, different name, different debtor. Robo witnesses and lack of personal knowledge. Appellate courts often reject this. Amount, balance, inaccuracies. If they cannot prove how the balance was calculated, interest, accrual, fees, that alone can defeat summary judgment. FDCPA violations. Even when a debt exists, a borrower can win if the collector misstates their debt, sues without proper documentation, uses misleading representations. Courts routinely hold a false and misleading representation under 1692E is actionable even if the debt is valid. Why these wins often happen on appeal. This ties directly into, my teaching. Trial courts often accept affidavits too easily, shortcut Civil Rule 56 analysis, assume default equals liability. Appellate courts enforce evidentiary standards. They scrutinize affidavits and require actionable proof. Trial courts focus on volume. Appellate courts focus on correctness. Now, the limitation of FDCPA wins. This is critical. When defendants win, the debt is often not extinguished. The case may be dismissed without prejudice, remanded, refiled. So the win is often procedural, not substantive. Now, contrast that with the CAC case. This is where your case separates completely from the rest of the pack. No disrespect. You didn't rely on the FDCPA. You didn't argue they misrepresented the debt. They lacked documentation. You argue the transaction itself is mischaracterized. The economic substance is different, meaning, Your Honor, look at this contract. This is what they said. Your Honor, this is how the transaction really went. It went like this. This transaction took place with them. Then this transaction took place with them. The first numbers tied into this second transaction. The second transaction, the numbers tied to the third transaction. And this is why these numbers are on my contract. This is why you see this $18,000 finance charge. Let me explain why it's there. This is why it's there, Your Honor. It's there because of this. This transaction here, this here, you see this here, this amount there. Okay, you see that what they did here, they here. All that, you see what they did? That's the system. That's how the system operates. So when you understand how the system operates, you can look right through your contract. You look right through the contract. Matter of fact, I'm going to use this contract as evidence of your system. Oh, I never dispute the contract. I use the contract as evidence. Since they didn't bring the complaint, I brought the complaint. I used the system against them. If I could just put it simpler, I used the finance system against them. Because they're part of the same system. I used their own system against them. AKA, I beat them at their own game. And the system, there's no differentiation between how the system works in mortgages, how the system works in autos, credit cards. The system is the system. Many people online have an understanding of the system, but their understanding of the system is from a consumer standpoint. Many people don't have the understanding of a system from a balance sheet examiner, from a custodian standpoint, from an investor standpoint, from a corporate finance standpoint, from a regulator standpoint. They don't understand the contract from a consumer standpoint. Your lender's not looking at the contract from a consumer standpoint. They see a totally different thing. One contract has 5 different meanings, 5 different lenses. That finance charge means 3 different things. Three different numbers. If it means what you got to owe here, it means something different to the finance company. It means something different to the investors. You argue the transaction itself is mischaracterized. The economic substance is different. The legal obligation is fundamentally flawed. Meaning, from the beginning, the moment I signed the contract is the moment the contract was invalidated. As stated in your complaint, you sought recharacterization of the transactions in federal law, not just defense to collection. You attack the foundation, not the collection. FDCPA cases attack how they collect. Your case attacks whether they have anything to collect at all. FDCPA cases attack how they collect. My case attacks whether they have anything to collect at all. FDCPA equals you collected wrong. My case, there is no debt in the form you claim exists. Remember I told you those numbers? Remember I told you those numbers on the contract? Remember I told you none of those numbers are real? Remember I told you? None of what you see on the contract is real? It's a magic shit. It's a house of cards. None of those numbers are real. Remember, understand the systems that created the numbers. Then you will understand the numbers they throw in your face are not real, because I understand the system in which creates those numbers. There is no debt in the form you claim exists at all. You see how that just bing? No, I don't owe this. No, I don't. None of this is real. You really? Stop playing. I don't owe this. Nah, you can't collect. You know that. The moment I signed the contract, you sunk yourself. Why do you think I stopped paying? Oh, you thought I stopped paying to just going to send you a bunch of administrative documents, and then when you repossess, I file a lawsuit against you because I'm mad? No, everything was tactical, CAC. I was lining you up from day one. That's why I ain't mind paying you. The more I paid you on a contract that I already know is invalidated, the better I look in court. I'm just creating the narrative. Your Honor, this contract was invalidated from day one. I was under no legal statutory authority to pay, but I still paid. How you think it's going to make me look in court, CAC? You think they're going to dismiss my claims, or you think they're going to make you respond to them? What are you actually going to say? I understand how you operate internally. You know that because I sent you your own internal operations, but I had enough professional courtesy not to file it on the record. But you know I know how you operate from the inside. You know I know that. I know you was wondering, like, where the hell did he get this from? Yeah, I sent you your whole operations right in front of you, right? This is how you operate on the inside. This is what the dealership that screened when the borrower's on the other side of the table. You know, when the agent is sitting down, I know what that screen's saying. I know what you communicating with them. Here, you think I'm lying? Here's a copy of it. But I'm not going to file it on public record, though. Don't worry about it. And I have it. I left it out. Then I hit him with the most damaging information. I'm willing to settle with you. Don't worry. I'm going to leave it out of the public view. I understand the game. You just not going to get me, but I understand. I ain't mad at you. I ain't even mad at you. Get your money. I'm not even mad at you. It's just business. Credit acceptance. It was nothing personal. It was just business. And I was starting to set you, and everything I was, implementing in my own case, I'm teaching to set you in a few months. So, this is just a flagship. Let's see how it goes. Before, you have a flagship, you got 10 episodes. Those 10 episodes do good. They pick you up for a full season. That's that. Let me see how this goes with them. If this do good, I'm open to set you up, because everything about the system, everything is going to be implemented and set you. Oh, we settled? All right. Set you open. Come on, y'all. Yeah, we got him. This is the system. See, set you is not confined to an auto. It's not confined to a mortgage. It's not confined to a credit card. Set you It's surrounding around the system, how the whole system operates. That's what it's. 3, you filed while current. Critical again. Default cases, borrower is already in breach. Creditor narrative is intact. Your case, no default, no breach, no damages narrative. That forced CAC into defending the structure, defending their internal accounting, and defending their internal classifications. Remember, it's internal. You never see what they do in public, but now you got to defend it. No, hell no, they're not going to defend that. Your outcome reflects that difference. Your settlement confirms the strategic advantage. Account closed, no further collection, trade line deleted, lawsuit dismissed with prejudice. FDCPA win stops bad collections. Your case forced a complete exit. Why your case is rare and more powerful. Most borrowers wait until default, defend the case, and rely on procedural defects. Well, I acted early. I controlled the posture and forced substantive review. In the default and the FDCPA cases, a debt may exist. Wins based on violations, often procedural, may not eliminate obligations, often requires appeal. My case, you follow what I'm saying. You file while current. There's no default narrative. Substantive legal attack. Forced structural analysis. Ended with full resolution. Borrowers in default win when collectors make mistakes. You won by making the entire framework the mistake. So it wasn't me against them. I didn't attack them. I attacked the system. This is how the system operates. This system, the mere fact that it operates the way it does, is in direct contrast with consumer rights. Not specific documents filed. The mere fact that y'all run it like this is a violation. I think that's a more stronger argument than any piece of document they're filing against you. The mere fact you account for it like this is the problem. The mere fact that you structured your own financing like this is a problem. The mere fact you classified this on your financial statements of position is a real problem. The mere fact you put a finance charge on the contract is the problem. Wasn't the finance, the APR, the numbers, that was the problem. The fact that you have it there is. The fact that you even have the contract the way it's styled, it's the problem. Not the obligations arising from it. The fact that you even operate is the problem. The fact that you're even in existence is the problem. And you can't even say anything. That's your problem. You can't even defend it if you wanted to. Because it wasn't just you that you had to protect. You had to protect the system. And I knew that. You can't really say too much because the bigger picture. So filing while current, you're not attacking the lender's documents. You're not attacking the creditor's affidavits. You are attacking the system itself. I believe that is a better approach if you want to implement change on a broader scale rather than continue to wait to be sued to defend, continue to wait to see what they filed to attack it. You don't wait for them to make the mistake, because set you already stand, you already understand that the system is the mistake. The mistake has already been made before you even filled out the application. You slap an application in our face, but we understand the system that created that application or the contract. We understand the system that created the contract. We understand the calculations and the assumptions that you use to throw those numbers as an obligation I owe. So it's impossible to be attacking the numbers itself per se. We're attacking the very system that you use to present those numbers. That is the heart of your system we attack. The heart. So when you understand the corporate finance lens, the investor lens, the regulatory lens, the legal lens, your consumer claims you can't help. You won't be able to help that your lawsuits read. And I say this in all sincerity. You can't help that your lawsuits now read like a class action lawsuit from a consumer.
You're rocking with the best. You're rocking with the best.
It's not even anything that you're going to plan for it to happen. It's just going to read like one. Another thing you're not going to plan for is this one consumer lawsuit. It transcends the consumer arena. Bankruptcy, you would win. If you were the IRS, you would win. If this was a securities lawsuit, you would win. That's why I don't like to stick in the consumer box, because the arguments that we raise, they're nothing like consumer arguments. Now, given the relationship of the parties, consumer laws, consumer claims, that's just used to bring your arguments to the door. This is why we file federal lawsuits with set you claims. You don't go into state court. No. It's too technical for state court. State judge is not going to follow. You go to federal courts because they follow. but you manipulating the system and controlling the narrative so much that all the technical things that's used in set you the things that I teach and advocate for, those are used to explain why your consumer laws was violated. Not just saying that a consumer law was violated, or they did this, so my rights were violated. So you're going a step further. You're explaining why they even did what they did in the resulting violation. That's why we go to federal court to have that conversation. But the legal causes of action are the consumer claims. That's why we grant this federal court supplemental jurisdiction. But we're really going into federal court to talk about their system. But since you got your legal cause of action down pat, the door's open for you to talk about it. State courts are not equipped to handle set you claims. Federal courts, remember, you're merging technical issues into a consumer complaint. Corporate structures, corporate finance, internal substance, accounting valuations, accounting classifications, securities laws, investors laws, regulatory laws, academia, substantive case laws, all used to support your legal cause of action. When you understand the framework, this is why the way I teach it and set you could speak on accounting and securitization and not get your cases thrown out. But if you look all across the landscape, everybody that uses accounting and securitization, they get their cases dismissed and thrown out. What's the difference? It's because they use accounting and securitization from the mindset of a debt collection, from the mindset of debt elimination. We use accounting and securitization and securities law to attack their system. As a matter of fact, I don't believe I don't owe the debt even comes up, even came up in my, that's not even a focal point of we don't owe the debt. We don't even, we don't even get into that. Want to know why? Because that conversation is going to take care of itself without you even having to talk about it. And it's not the fact that you don't owe the debt at all. It's not even the focal point. The focal point is, you sure I owe this debt as you presented? You sure this is what I owe? And I don't need to see your chain of ledgers. I don't need to see your chain of assignments. I don't need to see your ledgers. I don't need to see any transaction documents. I don't need to see it. I don't need a securitization audit. You don't need it. Want to know why? Because you understand the systems that created the numbers on your contract. What you need to see a ledger for? What you need to see a funding source for? For what? I know how I don't need to see this funding source document because I understand the structures that you use to obtain the funding. You need to see the funding, who funded what. I already know who funded what. I already know how you got your money. I don't need to see it. I don't need to see it for. I already know it's there. How do you know it's there? This is where it gets to the point where, Your Honor, This is why they charged all this much. So you know it's there when you can explain the why, not the what. What's the what? The violation. But why is it a violation? And not explaining the violation based on the statute says it's a violation. Explaining the violation based on their system. This is how their system operates. This is why this number's there. You see how they look at this finance charge, Your Honor? But you see what they call it for me? It's a finance charge to me. But it's not a finance charge to them. It's a spread to them. It's an over collateralization to the investors. And it's a disclosure requirement under the regulators. But it's a finance charge to me. This is what I got to pay back for them loaning me money. You see, Your Honor, I'm taking this number and I'm giving you 4 different ways that they view this number. Here's the amount they say I owe. Your Honor, that's an impossibility. Why is it an impossibility? Well, let's just look at their financial statements and position, and I will show you why it's an impossibility. Matter of fact, sorry, there's an exhibit. Your Honor, the mere fact that they even filed a foreclosure, that's actually the proof itself. No, the foreclosure itself is proof. Oh, Your Honor, this is what they forgot to say in their foreclosure complaint. This is what happens when they file a foreclosure. This is how the accounting works when they file a foreclosure. They didn't say any of that when they filed their complaint. Look at those numbers, Your Honor. Now, let's look at what really goes on. See how they're trying to play fast and loose with the courts? Hey, Your Honor, I've been paying on this mortgage for about 5 years. I've made $2,700 a month, paid taxes, almost $20,000 in taxes. Your Honor, this is not the true carrying amount of the receivable. It's not. As a matter of fact, the number is more in this ballpark. So the extra $40,000 I paid in interest, this is where that went. Can we get a order? Can you restructure this transaction to actually match what's really going on? $40,000 needs to go there. Yeah, this is where the extra $40,000 went, Your Honor. We call this a traditional lending? Is that what we about to call it? I thought interest is, and I like to use the IRS's definition of interest because they have the use of forbearance of money. Well, none of what I pay the interest has anything related to the use of forbearance of money. So why'd you call it interest? Did you misclassify this item of income? Uh-oh. You know what happens when you mess up one, it messes everything else up. Uh-oh. Are you understating your income and overstating your expenses on purpose? Do you really have the unrestricted right to collect this principal interest payment stream from an accounting standpoint? Not from we can get off the statutes. From an accounting standpoint, ask yourself a question. Do you really have a right to the principal and interest? Because you know what you're supposed to do before you collect from me. You know you haven't done that. Hey, US Bank, do you notice that everything I'm throwing at you is what you already recognize as a risk factor that you're scared of? You notice that there's nothing I'm saying that you don't already deem a risk factor? Hey, Loan Depot, you get those numbers situated for September 1st? I know you've been having a hard time the past two hearings for them numbers. You do realize that there's no number that you could bring in right now that's going to change anything. You do realize that though, right? See what you is. Hey, Loan Depot, why haven't you filed anything new on the record? Why are you just so silent? You ain't got no more exhibits for us? Oh, you finally caught on. The more you file, the more you sink your ship. The more updated figures you file, the more you sink your ship. You finally catching on. I got you. You finally catching on, ain't you? Took you a while, but you catching on. The more you file, the more you're gonna look bad, right? The more you file, the more you can't support. I mean, you could try it, but I mean, there's no secrets, no mystery. What I'm gonna do, I'm gonna attack it the same way. You wanna know why I'm so open about telling you I'm attacking the same way? Because there's nothing you could do about it. Remember, understanding your system. There's nothing you could do about it. Hey, Loan Depot, I thought you said at the trial, I think I heard the testimony that these were Loan Depot's records, but you use a totally different system, a LLC, to store the records. Use Mello. The witness that you put on was from Loan Depot. Mello is a wholly owned, separate entity owned by Loan Depot, but it's still its own entity. So why don't you bring somebody from Mello? Why you bring someone from Loan Depot? I mean, it has its own LLC. I think it's an Inc. Yeah, Inc. It's its own separate corporation. But you testified that those were your two, Loan Depot. Hey, Loan Depot, you forgot to redact that part at the top. I mean, I already knew, but you just gave me the door to talk about it now because you made it part of the record. So now I can talk about it. And let's sprinkle a little consumer in there. You can't just read from a screen and think you can substantiate the numbers. You know that, right? You do. Loan Depot, you don't see what's going on here? You had two evidentiary trials. 2 times. You couldn't get those figures right. 2 testimonies from the accountant and the other custodian, whatever. And you still couldn't secure the summary judgment. Why? It's because she's with someone that now understands how your system works. And you're at your limitations to how much you can defend. You see how I shifted the whole conversation away from her default and the way she, her judicial default, which she was already in when she got. You notice how we remixed the whole thing and made it about your system now? Strategically, just made it about your system. And I'm going to treat you the same way I treat CAC, the same way I treat Navy Federal, the same way I treat them all. Explain your system. See, you think I'm asking you to explain the numbers because you hear me say explain the numbers. But I'm really telling you to explain your system. Oh, we know none of y'all ever want to talk about it. We know. Come on, explain your system. Go ahead. I'm listening. I'm here. I ain't going away. I'm listening. I know. Can't do it. Newsflash. None of them ever can.
You're rocking with the best.
That's a fact. Now, you think I'm lying? Let's go back in time. Let's go back in time. Let's go back in time. Let's take a trip down memory lane. How about we do that? Let's take a quick trip down memory lane. Let's take a quick, not a long trip. Just take a short trip. It won't even last an hour. Think about a quick 18, 20 minute trip. Let's just take a little quick trip down memory lane. I promise you, it won't. I promise you, it won't. It won't be a waste of your time. I'll just say that. Let's see. We're gonna pull it up. Let's just pull it up right quick. Before we get to the memory lane, this was a good one. It's what a college professor had to say. So basically, he had to preface it that he was taking a class. He didn't want to just come out and tell him that I gave him my accounting document because that's what he's getting his degree in. So I basically gave him my accounting letter that I sent to credit acceptance and told him to say, let me know what your professor has to say about this. AKA set you. He didn't want to say he got it from me. So he kind of prefaced it like an assignment. So yeah. YouTube. A class assignment?
Yeah.
Oh my God. What? Are you serious?
That's what he kept saying. And I was like, he was kind of saying like, yeah, it seems legit. It seems real, but I'm a professor and you're asking me about an assignment. That's what you're asking me. You know what I'm saying?
Say that again, sir.
The vibe I got from it was you came up here to ask me about a document in reverts to an assignment. And I told you, it seems like, yes, it's a genuine accounting issue. It seems like it's a legitimate issue, but that's how I seen how he was construing it. Like, yeah, you came up here to ask me about a class assignment from a student from another class. And I gave you an answer. That's it. And I was like, okay, I respect the fact that he still, looked at it and said, yeah, this seems legit, but we spoke about an assignment and that's it.
Wow. So he didn't want to get into. I told you, bro. He didn't want to
go any further.
I told you because he knows. Like, and the reason why I know he knows because he immediately pinpointed it was an accounting issue. That's the whole point I was making. That's the whole point. It's about the accounting.
I was like, this teacher loves to talk. He loves to talk about. He did not want to talk about none. He just, it seems like an accounting issue. That's it. Quiet. I'm just there.
Yeah.
I took a few days to go because I wanted to try to understand a little bit of it and actually get a conversation out of him, but nothing. He didn't even want to talk about it.
And he likes to talk.
He loves to talk about it. He loves to talk about fraud for sure.
Wow. So what was his facial like?
Yeah, he wasn't really making eye contact with me, but he normally doesn't really make direct eye contact, but his reaction, you could just tell it was just like, this is some shit. Like he was scrolling through it, looking at it, reading it, and like he was just kind of like, it was like he was kind of shocked, but trying not to make it seem crazy,
Because they don't even teach you that in college. That's why. When he got it, he was like, damn, the gig is up. How did he get this? We don't teach this in our curriculum.
You're rocking with the best.
That's why I said when I'm enrolling into the advanced master's degree in accounting, to be nosy. That's why I'm rolling, to be nosy, to see if they really going to hit on what we cover and set you. That's why I'm doing it, to see if they really going to do it. You surprised them.
It was apparent. Yeah, it was.
He was expecting that.
Yeah, and I just kept. It's like I'm trying to get stuff out of him, and he's not trying to answer. I'm trying to act like I know, but I don't know. You know what I'm saying? Just to see if he'll try to fill in the blanks. But he wasn't. He just said, "Yeah, it's an accounting. It's an advanced. Yeah."
Wow.
So I made sure to know. Like, I was like, "Yeah, he's not taking a class at a university though. He's taking a class like online with a group of people that he paid for." He's like, nothing, just quiet.
Wow. So basically, it seems like he was trying to figure out who the fuck is teaching this. Like he was basically trying to say, like, who the fuck is teaching this?
I'm not sure if because your name, I'm pretty sure your name is on it, but I'm not sure if you read.
Right.
He really looked at the first page, and like from the first page, he was like, "Yeah, like I'm not trying to read any further." But he admitted, you know what I'm saying?
Right. That's all it takes for them to determine whether what you submit to them has any legal bearings. The first that you think the lawyer. So when y'all send y'all 5,000 pages of administrative claims, do you really think they're reading through it all? You got the first couple sentences to get their attention. You got the first couple sentences to get their attention. Yeah. There is no one. It's hard for everyone.
Shitload of notes because
standing and all it takes, we hasn't gotten, and it's like, hold on, 100% spot on. And I highlight the court on their mortgage. Hold on, let's get it. Get documents to them all they want. Yep.
And the point
Here we go.
That's cool because I'm.
He was a top dog at the SEC.
Here we
Talking
go.
about is the lawyer. It's the ex-SEC attorney that actually reviewed my complaint against credit acceptance before I filed. He was the first one to say. He was the first one to say that they was going to settle before they settled. He was the first one to predict that. Own personal like tactics that he has used in his 100 victories. And actually, I know who that lawyer is. He told me his name. I'm not going to tell y'all who he is, but I know who he is. He's a top dog. Comes from the Morgan and Morgan family. That's all I'm gonna say. So before I filed my lawsuit, that's who was reviewing my complaint. There you have it. Not the one that you're going to hear on here, the one that who he met with. So an ex-SEC attorney with all my securities claim, all my accounting securities claim, that's who actually was reviewing my complaint in all its stages. That's I already knew. I was highly confident when I filed it because I already had a top-level professional review it. He was a top dog at the SEC. He took down some. He a big dog in this.
That's cool because I'm doing the research.
But it's going to be a very
hold on. Let me find some things. Hold on. Complex peers isn't just like I get the reality of it. This is not a citizen arguments have no business. I got to find. Let me when we started that those people can tell God of pseudo laws $100 million of the most gain. And I got clients information. Come on. Everybody is and give.
They do this all the.
There we go.
Process. He said
there we go.
The key that which you're dead on, and he said that start.
Yeah, you can go ahead.
All right, so the attorney says that the mortgage note absolutely serves as. So
in my group, I discovered it was like late at night one night why I discovered where the lines was blurred. So I told my class, I said, y'all, I think the reason why the lines are blurred with the mortgage note is because they call it a totally different name and it takes on a totally different form after you file it. It goes through a metamorphosis. So I brought that up to the group, and then I had my friend ask the SEC attorney about it. So that's the context.
Process. And he says,
so this is why when you hear some block
that the mortgage note.
So this is why when you hear some blocked out, that's the reason.
Thank you, Trey. I appreciate you, man.
Well, tell me when to start.
Yeah, you can go ahead.
All right, so the attorney says that the mortgage note absolutely serves as in this process.
Was right.
And he says the deed of trust, he says you're dead on. And he said in the language is the characteristics. Okay.
Yes.
He says, and that's the key that.
So I note, and then I said, y'all, I think the deed of trust, I know I call it a deed of trust on the mortgage level. But remember, with multiple different lens, it's not a deed of trust. It's really that to them. So I had him confirm that. That's when he was,
If you go, or you go to the U.S. District Court or a state court, he said in this process, he said the key thing that you want to look for, he says when you're going in there is looking for.
This is a person who prosecuted finance companies. So you don't think they know what to look for. This is where I had help in understanding the system. He pulled the curtain back for me. Yep.
Of the initial documents going in through the process, he said they do this all the time, and he says they do it willy-nilly, and he says they break the chain of title, and he says they break the assignment and of it.
Yep.
And they said, and he says
Yep.
He says they blur the lines between it, and he says that is exactly where you attach.
Yep. Yep. I
And
knew
he
it.
says, and he says you can break apart that whole
Yep.
in documentation of this. He says they do it all the damn time. I said, what is all the time? He said 90% of the time.
Yep. Yep. Yep.
It's 90% of the time, it is nothing but business to those people. Now,
While we was driving on the golf cart,
Yes.
and so he filled my damn. I had a damn pad of paper. We had another driver
Yes.
driving the cart, and so I just took fucking like 25, 30 pages of notes.
Yes.
And so I sent him back my notes and some of what I'm preparing for you.
Yes.
And he says, from our initial talk, he said, your things that you got and you're preparing for whoever you're doing it for. He said, it's point on. He says,
he's talking about me. The lawyer saying, whoever you got, you're working with, you're doing, he's talking about me.
Facts.
And that's the point where he says, spot on.
Facts.
100% spot on.
All right, shut the fuck up.
They're treating these fields. They are some of the biggest assholes. You want them to have a heart. If you ain't willing
of this.
That's cool because I'm doing the research.
But it's going to be a very thorough dictation of this process and the points of it.
So all the stuff that he's giving me, I'm just adding it to my repertoire. I mean, I use everything. I may add this or this.
Oh nah, that lawyer pulled the curtain back. You would, oh my god, these people play vicious games, boy.
It's good for me because remember, everybody's situation is different. What motion is that?
So they go in the background.
What he said right there was, oh God.
Yep.
And he says, when I get done with them, he said, they don't even have a leg to stand on. He says they go in the back rooms with me and settle out.
Yep. That's
go in the back room and settle out. Well, I'm up under the professional umbrella. They went in the back room with me and said, so I'm just consistent. Yo, I've seen what this man has done. I'm like, bro, he just has that clout and he's known as real decorated. His family members and his daughter, I've got the paperwork. They literally refunded every mortgage payment she ever made and released the lien and gave her the house. I say, yo. But he's a fucking big dog. He's ex-SEC. Of course, they'll be scared when he pull up. And they respect him. Pro se, or you gonna have to work too hard. But they just they didn't even he didn't even have to file a suit. Just sent the letter like, yo, the heading, this is who I am. And they just, here you go. Settle out. Old as dirt. So let you come like the check went where see if these hold on.
District court or a state court, he said in this process, he said the key thing that you want to look for, he says when you're going in there is looking for of the initial documents.
Nah, oh God. That's what I look for right there. Because he gave it to me. Just
going in through the process, he said they do this all the time, and he says they do it willy-nilly, and he says they break the chain of title, and he says they break the assignment and go to notes because I took notes with him over 18 holes of golf.
To A.
Seats.
Yep.
And he says, and I brought up something extra because I said, because we are the initial person of that. We've got a security interest in it. We've got a legal interest into the proceeds.
Yep.
And he said, yes, you do. You got what's it called? He said it's called.
That is that word. That word means a lot. That's the legal term that you're supposed to use for. It's part of the terms I use in my settlement with CAC. Like I said, there's some things I got to confidential, like the title. I can show you that, but there was more that was given. But that word, he's not lying because I input that he's not lying. That changes, that solidifies the change in the nature of the position. It's not lying. So when people say you got to secure it in the proceeds, I hear him say it online, but I'm like, you're missing that key. You're missing that key term.
And he said that makes you a part of the process and the right to the proceeds.
An ex-SEC attorney, 27 years, saying they've already ruled. What makes you think I care about any of what these sovereign citizen social media teachers talk about? Because none of them know this. And I'm not about to be biased, but this is why there's really no, whatever. Not one of them taught, but just studied and learned it. Oh, you know in this 25 years. To come back in a week.
Yes.
I need a tan. Maybe I can find a tan in Cancun. Oh, yeah. All right. I'll be back in a week.
And all that shit.
Yes.
And she told me, and she's been doing it for 25 years.
This is the accountant. 25 years. Examiner at Deloitte. 25 years. This is the lady who reviewed my accounting documents.
Yeah. Because he uses her effectively to come in on the accounting side.
Yes.
So here's the misconception that people that know securities know accounting. That's not the truth. It's not the reality. People that know securities don't know accounting. But people that know accounting don't know securities. So the security norm. But if you work in accountings, you don't even learn securities because you got accountants for it. When you work in securities, you don't learn accounting because you got accountants for it. I know both.
She said he uses her.
Right there. He uses her to tear. When I talk to, I don't have a background. Then it's
dinner with me. She says, I'll break this down to you much more thoroughly. And she said, show you. And she said, get you a game plan.
Yes.
And I said, well, we kind of got a guy that's already on top of this.
Yeah.
He's talking about me.
And I said, he already knows all of this. And I just basically just reconfirming whatever he needed, you know.
Exactly. That's that. So, like I said, anytime I need a professional opinion, it's literally a text message away. Anytime I need a legal professional behind the scenes opinion, any answer I can get. If I don't know the answer, I can get the answer with ease. This is why I don't have that complex. Or I got to know every single, if I don't know it, I know I'm going to get the answer.
She said, well, he's right on the right attack. I said, he's been going at the accounting securitization issue. But all of this, and I get you a game plan.
Yes.
And I said, well, we kind of got a guy that's already on top of this.
That he's talking about me. We know.
Yeah.
And I said, he already knows all of this. And I just basically just reconfirming whatever he needed, you know. And she said, well, he's right on the right attack.
He's right on the right attack.
You're rocking with the best.
No, I'm not.
To this group due to your connections to the
whatever he needed, you know. And she said, well, he's right on the right attack. I said, he's been going at the accounting securitization issue, and but the attorney said that
I wish I had my
issue, and but the attorney said that
yes, sir. Yes, sir.
okay.
I'm gonna add that. Oh, Troy, good God, man. I wish I had my prompt right now. I'll drop the bombs. Yes, sir. Troy, man, you don't know how much valuable you are to this group due to your connections to the professionals, bro. Nah, for real, man. This is professional
But
confirmation.
you're the one that's the smart one, brother. You're the one that's put all this together.
Yeah, but Troy, like the have the professional confirmation and know that you have the right interpretation and the professionals are confirming it, man. Oh,
And if, like, really, you don't have lead team offers into a state case.
legit. Nah, you may want to add this. So, you gave me some key pointers, and that the initial. Sorry, y'all. I had to block this part out. Too much sauce.
Yep.
Right there.
And he says that he gets all of his wins based upon fucked up kick accounting. Okay.
Yep.
All right.
That's why you got to tap in with me. The value is worth it.
Yep. And he says it's just basically if they can't.
We discussing in courtroom documents and tactics right here.
And he said they do this all the damn time.
Yep.
And he said
that's when I said the system. You heard me talk about the system works. Everything that we're talking about here, I implemented. He wasn't lying. He wasn't lying. All of them, it hasn't been like, well, this way, but no. In a mortgage, auto, and any securitization, it's all going to be the same. He's not lying. He's not lying.
These SPVs are notorious for it.
Yes.
He's not lying.
That's what I said. Because, Troy, it's impossible for them to do it legally and stay within the confines because they would have to pay taxes at every stage.
Yep. And he told me, he says, the reason that is so that they're trying to avoid taxes.
Yep. That's when most people think it's securitization. Oh, just to steal more money, securitization so they could double up, or they do it to do that. No. When I found is with all the professionals confirmed later, it's not. It's just to get out the taxes. That's it. That's what led me down the path of mischaracterization of income, mischaracterization of items of income, mischaracter. I was like, oh, this will fuck up their whole system if this goes to term. Oh, yeah.
Yes.
What do I always say in the group, y'all? If they really did this legally by the book, they'll be paying. So, okay. So, this is why they hate for you to the metrics on how they approve you versus how instantly when you start getting shit in the mail. Come on. So that portion of the consider Supreme Elite Tennis. You know what I tell you? I get purchased. Yeah. At it from this angle. Well, I remember once that every
is so that they're trying to avoid taxes.
Yep. Yeah.
Remember I always say, if they did this the right way, they'll be paying millions of dollars in taxes at 2 stages. From the sponsor to the depositor, then from the depositor to the issuing entity, they have to pay taxes. Shit, they even got to pay taxes when you sign the deed of trust.
They're dirty. And he says, you got to get dirtier than them. But he says, as long as you can get dirtier than them, and he says, you can stand on your spot and not move. He said, you'll win every time.
And I got dirtier than them. Here's what the dealership sees behind the screen. I got dirty on them. I pulled out dirt. They would have never thought from a pro se I would ever pull on them. I pulled all their dirt. Man, I've seen so much of the fraud. I pulled all their dirty tricks out on them. I say, yo, y'all really look at what you're doing. Oh my gosh, this is horrible.
You heard me say it in the group: blood, guts, and gore. Guts and gore. That's the only thing they respect. That's the only thing they respect.
Yep. But he says that, you know, he says, he says, I wear these guys out. He says, man, he says, I take them into Discovery, and he said, I wear them out.
Oh yes.
And he says, and he says, you know, he says, I attack them in depositions, and
Yes.
he says, you know, he says, by the time I get done with Discovery, he says, they don't even want to go before the judge now. He says, they're talking money.
Set out.
And he says, we're talking in a back room. And he says, we just send a conference agreement to the judge.
Yep.
And then we settled the matter.
Yo, that discover. That's what happened. This is what he said. That's what happened with me. Yo, the discovery that I have, you won't find it anywhere but the professionals. Like, that's one of the, and I will admit, that's one of the things that attorney gave to him to give to me. Just the discovery stuff he used in his litigations. I have that. I have a top SEC like discovery. Can you imagine what's in it?
Doesn't matter right there. And that's what I told the group. I said, hold on, man. I've seen a lot of these cases where there's a joint motion to dismiss because the matter has been resolved privately.
Same thing that happened here. But guess what? You want to know I know why it's so powerful? Because I sent a copy of the discovery to Credit Accept. I didn't file it because it wasn't at the stage yet, but I sent it to him. Like, yo, when it gets to discovery, look what I got. They got it before it even started. If it gets to this stage, you know this is how I'm coming. And I know you can't get out of it because I got this from an ex-SEC attorney. So I know you ain't getting up out of it. Well, I ain't telling who I got it from, but that's what I was thinking.
Seeing it. I said, oh, they don't want this in court. They don't want this in court.
And so he went over with me a lot of the things on the civil rules of procedure because we were playing 18 holes and stuff.
Yeah.
And he told me that you know, because I've got a pretty good understanding how the rules and stuff.
Yes.
I've got a legal background. And so I'm going to create for the group.
I think T. Dot here, I think he's a chameleon. I think he knew way more about the system than what he knew. I think he came to my group to see if I actually knew what I was talking about. There's no way he's connected to all these people and he comes to my group. Oh, I'm here to learn. I knew, and it came out later on that he was fact checking me with his attorney in real time after every class. He wouldn't really say much. He wouldn't say much for like the first year, but he was fact checking me with the SEC attorney the whole time for a year straight. I didn't even know. Can you imagine if I was wrong? Golly, you talking about being fact checked in real time. I didn't even know.
Basically, what I call it, rules for dummies.
Yes.
Just a little thing that this is what you use this for. This is what it's for.
Yep.
And I'll throw it out to you when I get it all done. And
that's a part of this. When you become part of the Supreme Elite team, with that, you get that too. As I say, you get professional, like, insight. You get what the pros do.
Put it before you, and then you can decide who gets and what gets.
Yep. I definitely will because
well, first and foremost, that right there, that's just by sitting in. Don't worry about that.
Test.
You got to know warfare. You got to know legal warfare. That's what the attorney said. You got to know legal warfare. He said. He said if you ain't. He said if you ain't willing to step.
Rule procedures in the state.
You heard what he said? What do I say? For you to do.
You got to know legal warfare. He said. He said if you ain't. He said if you ain't willing to step inside the courtroom. He said you can only do so much with paperwork exchange.
Yeah.
Told you. Heard what he said? If you ain't willing for an update on your court case.
President and
live.
Yeah, so like I told you, he used to be 2 to 3 down on the totem pole in the SEC.
Yes.
But now Donald Trump has gave him a special advisory role.
Oh,
to where
wow.
they just tapping his brain for the knowledge between him and the president and the financial management services.
Yep.
The looking for.
Oh shit.
You can decide who
Yep.
gets and what.
With your friend, the attorney.
He says he must be on his the Treasury Exchange advisor.
Oh,
So yeah. Hey, you must know every move they make before they even move. That's a fact. And when you study that's and this is why he got
oh,
where
wow.
they just tapping his brain for the knowledge between him and the president and the financial management services.
Yep.
The Treasury, the IRS, and he's like an advisory go between for them and the SEC.
Wow. Because and that's what they do. They get these professionals on, hang on as advisories to advise. Yep, that's a fact. So Troy, so according to your conversation with your friend, the attorney, what we go over in group is right in line with the legal standards and the professionalism on how it has to look and what you need to know when you attack these people.
The words that he used was, "You're going about it standard operating procedures."
Okay, perfect. Because that's one thing I always want to make sure is that I got the right interpretation.
And he said, whoever you got to doing this.
That's a fact. So Troy, so according to your conversation with your friend, the attorney, what we go over in group is right in line with the legal standards and the professionalism on how it has to look and what you need to know when you attack these people.
The words that he used was, "You're going about it standard operating procedures."
You're rocking with the best. You're rocking with the best.
We're gonna do that affidavit of truths. Gave me the heart and the life. They're learning stuff that they did. So
you're rocking.
That's a high praise from an ex.
And he said because he's.
So I just stick to the Supreme Elite team, man.
Okay, perfect. Because that's one thing I always want to make sure is that I got the right interpretation.
And he said, whoever you got to doing this, he says, he must be on his game. He said, because he said, most attorneys that's got 10, 15 years of practice, he said, don't even understand this language and procedures.
Oh.
You're rocking with the best.
On his game. No, I swear to God. Because they know this is out the mud knowledge. Attorney I'm talking, I'm representing. That lady don't know. Her law story teacher.
He must be on his game. He said most attorneys it's got.
Perfect. Because that's one thing I always want to make sure is that I got the right interpretation.
And he said, whoever you got to doing this, he says, he must be on his game. He said, because he said, most attorneys that's got 10, 15 years of practice, he said, don't even understand this language. He said, they don't know nothing about this realm, this world. It's a foreign world to them.
Yep. Foreign. Troy, let me ask you a question. Why do you think they go through so much to do it like this? Like, what is it? I know. I mean, he told me this right here. I asked him
I did ask him a question, not this time, but another time. I asked him, I said, why do they go to such simple means to be able to do this? And he said, well, watch this. He said, those that are in power and money, they stay in power and money. And he says, let me just tell you a real number. He said, you won't find out. But he said, I know from being on the inside. He said, the 08-09 bailouts was $29 trillion.
Wow. Wow.
$29 trillion. And he said, do you know how many 08-09 bailouts?
Remember, it was all on the news, an $800 billion bailout. Remember the $800 billion they kept putting on the news? God damn. Package. Remember they kept telling that's what the banks are getting, $800 billion. Remember that $800 billion package? Or was it 800 million? 800 million, 800 billion. Remember that stimulus package, the bailout? This is the real number. We wouldn't have never known.
Wow.
$29 trillion.
That was the official bailout number. Would have never known. I know I wouldn't have. These gurus wouldn't even know anyone to even have that information.
Yeah.
That they bought with that money. And he says, the reason for it, he says, he says, it's an illusion house of cards is what he said.
An illusion house of cards. So on
those that are in the high positions, they're going to protect it.
Yep.
Till death do they part. That's what he said.
Wow. So it's not even personal against people. It's just the game.
No. Yeah, he said it's nothing. He said it's nothing personal. Nope. He said they don't want to.
Sure, I think only the Supreme Elite team is taking notes in the new coaching family.
So your friend knows the game.
If that's just the game. That's just how the game goes.
Yep. And he says, I just told you the game. You said your friend knows the game. He said, study that parts of the game, the secondary, recharacterization, securitization, and accounting. And he said, attack it on that, get brushed up on how to litigate in courts.
Yep.
And he says, you'll win. He said, you'll win.
Yep.
And he says, don't get discouraged. He says, you got to perfect your craft.
Yep.
He said, do you think that I could win 100 cases in a row when I start now? He said, hell no.
Right.
He said, I got so many damn bumps and bruises and punches in the nose.
Right.
He's like, he said, all right. He said, I got my ass handed out to me on silver platter. And he said,
Right.
He said, now.
Ex-SEC attorney admitting when he first started out, he was getting his ass handed to him too.
You're rocking with the best.
All this online 100% wins every single time. You never ever took a L, never ever in life. They're lying to you. Because this attorney here knows way more. Way more. Oh, I only win. That's all I want to show you. 100% success rate. How long have you been doing this? I only had 2 cases. Okay. Of course. Being here 10 years or longer, and let's see how the success rate lasts.
Now, he said, now I'm the one doing ass handling.
Right. I tell everybody, losses are part of the same game.
It's all part of the game. This is a year ago. I've been saying this. I've been saying this. This video is a year old before I filed my lawsuit. See, this is at the evidence gathering stage. Before I filed. And the attorney gave me a back door and I walked through it. They didn't even see me walk. They never see me walk through the back door. I see everybody going. He gave me the key to the back door. This is how you get them. It's all part of the game. You think that lawyer was able to get to 100 victories starting out? You're gonna take your bumps and bruises starting out. That's wins and losses are all part of the same game. You can learn something from your wins, and you can learn more in the losses.
Facts.
The losses are sometimes more valuable than the wins. Want to know why? Because the losses, you learn more in the loss than you learn in the win. Look at your average court case. When people get rejected, you can learn what they did wrong, and you can learn how to meet the standards more than you can do in a win. When an entity wins in a court case. Losses are all part of the game. You cannot have your wins without losses. You have to take your L's before you can win. That's the reality of the world. But yep. So it don't come by no surprise. It don't come by no surprise when I reached out to a class action law firm and emailed them a copy of my lawsuit when they called me back on a Tuesday. Blown away. Yeah, went over it in my group. They didn't even understand how these concepts can apply to a consumer case. They said, oh, we knew this applied to the investor side. We had no idea this could apply. Like you could be tied back to the consumer side. They said, remarkable, unbelievable. So no, none of this is taught in everyday settings. Because if it was in mass, many people would not be waiting to get sued before they did something about it. That is direct evidence that what I'm talking about is not taught in mass. And I'm not saying it's a bad thing. I'm just saying that it's not, because you wouldn't have the pressures of always trying to defend when they're trying to sue you. You would get out and have the horse before the cart. You won't have to wait. You could take action while you're current. That's the mindset I'm trying to get people out of, is always waiting. I defend this, analyze. No, you make them defend you. YouTube, talk to you later.
Run it up, running band. It's get on my team, they know who I am. They rolling the dice, we won cause we playing. The things that they teach don't know how to stand. I'm a wrist like a stage, they can't glance. You look like you wanna let go of stress. What's up? I thought so. Oh, I am the blueprint. If not, why you copy me, fam? What's up? I thought so.